This is a webinar about 3C leave and Tier 1 investor applications. And so we've got 3 members of the 5 St Andrews Hill immigration team to present to you this evening. Hopefully it will be practical as well as give you a good legal background in the topics that we're talking about. We've tried to make it as interesting as we can. I know that some of these topics are quite technical as well. There will be, of course, the detail in there too, but stay with us, and if there are questions that you have, then we can deal with them at the end. You can see we've got Ben, Keith, and Alexa with us as well. I think probably everyone's joined us now that's going to begin. Everyone else can catch up. So as I said, 3C leave and Tier 1 investor applications we'll be touching on as well. We're going to start this evening with Ben, who's going to give you an overview. And then we'll move on to Alexa, who's going to particularly focus on one recent case you may have already heard of, the case of Akinola. And then I'll be dealing with a third section, hopefully tying it together, giving you a bit more of a practical application of what we've been talking about. And as I mentioned before, if you see at the bottom of your screen, there's a Q&A button. Any questions, you can put them in there, and we'll do our best to answer them at the end. So I'll pass on now to Ben. Ben, please take us away.
Thanks, Mark. I think Mark's, you're going to help with the PowerPoint, but what I'm going to do is just give you a very brief overview of the law in this area in relation to 3C leave, a little bit of Tier 1 investor, although Mark's going to deal mainly with that, and then also the route to ILR using the long residence guidance. I've been lucky enough to be involved in a number of the cases for the Secretary of State on this topic, but also act for individuals the other way. And there are a lot of cases coming through in the last 18 months, 2 years, in relation to the interactions between 3C leave, between paragraph 276B of the immigration rules, and how that interacts with Rule 39E of the immigration rules and obtaining long residence. They don't interact perfectly, I think is going to be is my conclusion. And there's quite a lot still to be settled. There are quite a few grey areas, which makes advising clients quite complex as to the options they have. But let's start with the basics. And the basics are that Section 3C of the 1971 Act was recently introduced, not in 1971, and is used in order to provide automatic statutory extension of leave to remain in certain circumstances. And those circumstances are, as explained in Parliament when the different iterations of it have been put forward, it's designed to prevent individuals who have an outstanding application for new leave or for variation of leave to continue to have status in the UK whilst that decision is being made. Because up until then, it was essentially a discretionary on behalf of the Secretary of State, and 3C leave has incorporated that to give everybody who is awaiting that decision leave to remain in the UK, so they're not subject to bail conditions and to removal of other penalties. And that's quite important because many people don't want to become overstayers when their application is refused and then they have an appeal. And in general, it's fairly easy to understand and it works fairly well. But there are a number of scenarios, as we're going to see, in which it is far from clear how 3C works and how it necessarily interacts with paragraph 276B when somebody applies for long residence under the 10-year route. I'm just going to deal very quickly with the law. The next slide is section 3C. Now this is a slightly older version. I've decided to use this one because it's the one that's probably most relevant to current clients, but there is a new version of 3C leave. But essentially, this is the text of it. And that the section applies because what I'm trying to look at today is really the interaction of 3C leave with either 276B or long residence. So the section, so 3C obviously applies if a person has limited leave to enter or remain. In the UK applies for variation of that leave. And that the application for variation is made before the leave expires, and the leave expires without the application for variation having been decided. Now, what this has led to, and what a lot of individuals have tried, is a sequential application for various different types of leave in order to elongate lawful residence to try and get to the 10-year mark, to sort of eke out the lawful residence in the UK by making by varying an application as soon as new evidence comes, often for legitimate purposes, but sometimes it can look at, particularly with long immigration, complex immigration histories, it can be led to abuse, and it can look as though when people make an application that in fact this is simply a method by which they try and eke out their time in the UK. But it is a legitimate way to eke out your time in the UK if you have a valid further application. So, I mean, the next bit of 3C leave on the next slide, it deals with 3C2, and which essentially says it's extended by the virtuous section during any period when there's an appeal, when the application is not decided or withdrawn, when there's an appeal, or when there's an administrative review, or one of those could be sought or is pending. So in the grace periods, you know, when you have a window in which to apply for either administrative review or an appeal, then your 3C leave pertains for that, or continues for that period until the end of the appeal period, and you can then extend that 3C leave by varying your application or amending it. And that's a legitimate source of legitimate way in which to extend your leave in the UK. So go with the next slide. There are various ways in which it lapses, and we're going to come to some slightly more complicated issues in that if you miss and I think Mark is going to deal with this, but there are problems if you miss that window of opportunity in which 3C leave applies, 3C leave ends. And Alexa is going to talk a bit in a minute about Akinola and how you can revive 3C leave in certain circumstances. 3C leave lapses if you leave the UK. And in certain other circumstances are set out at sections 4 and 5. The next piece of law that you need to, two of the cases on this, sort of more recently, are Bashir in the Court of Appeal and Iqbal in the Supreme Court from 2016. And we sort of thought that those cases had effectively settled what 3C leave was, how it operated, and how it worked. I'm not going to read the quotation out. But 3C leave itself is referred to in a number of Court of Appeal decisions in recent times, but often in passing and not necessarily as the specific issue upon which the court is deciding. And that has led to a lot of obiter comments, which haven't necessarily all been ad idem. And so Akinola, which Alexa is going to come to, does deal, we hope, with some of those points, although, as we're going to see when we try and work with some practical examples, it doesn't necessarily deal with every single scenario that it could do. The next slide deals with the interaction with paragraph 276B. Now, 3C leave is a statutory power. Paragraph 276B is obviously the immigration rules. They don't necessarily marry up, although perhaps they should, perhaps they shouldn't, but they don't necessarily marry up in the way that they work. Paragraph 276B is the process of applying for indefinite leave to remain on the after you've had 10 years of continuous lawful residence. And the issue that's been in a lot of the cases recently is that continuous lawful residence, particularly under paragraph subsection 1 and then subsection 5, which basically allows you to make gaps. There are gaps in lawful residence as prescribed by paragraph 39E of the rules, or previously at the discretion of the Secretary of State, which is a 28-day period. Next slide, please. So yeah, to 28-day period if it's prior to 24th November 2016, and then 39E after that. Paragraph 39E itself says you have a 14-day window. So providing the application is made within 14 days of the applicant's leave expiring and the Secretary of State considers it a good reason beyond the control of the applicant or the representative, provided in or with the application why the application should not be made in time, or 2, the application was made following the refusal of a previous application for leave, which was made in time, and B, within 14 days of the criteria set down in submittal 1, 2, 3, and 4. And then subsection 3 gives you the details of the overstay. So far, so good. So the next issue was an issue that perhaps we didn't think needed addressing, has been addressed by the Court of Appeal in the case of Ali from a couple of weeks ago, maybe even 10 days ago, about the meaning of what an in-time application in relation to 39E means. That's the case of Secretary of State in Waka Ali. If you're interested in reading that Court of Appeal judgment, and what in-time in relation to 39E means. And Mark's going to work through an example of how that interacts in a moment. The next, I can't remember what the next slide is now. Is that the next slide, or was that the end of my? That's the end of my slide. So before I hand over to Alexa, there are a couple of other things I just need to sort of talk about. So Mark's going to work through a tier 1 investor example in relation to a similar case that we've been working on for a number of years. But there are a number of issues that remain unresolved. For instance, in Hock, in which I acted as Secretary of State, we dealt with the issue of book-ended and open-ended leave. And whilst the Secretary of State won Hock, and the Court of Appeal found that you could only be granted 10 years lawful residence if you had book-ended leave, meaning 2 periods of leave bookending the period of overstaying. It is not entirely clear from Hock or from subsequent cases as to how long that bookend could be. I have been arguing on behalf of the Secretary of State, at least, that it's limited to the 14 days within 39E and others, but there have been recent decisions which marks, again, a recent decision of the upper tribunal case called Asif, which casts doubt of my interpretation. That hasn't been appealed. And so how long the bookended leave is or isn't, and how much you can legitimately take into account is not necessarily straightforward. I hope we might be able to resolve some of that today, but there are a number of questions which are still, I think, pending and will probably reach the Court of Appeal for decision in the next, I don't know, year, 18 months. So finally, that leads me to hand over to Alexa, who's going to deal with the recent case of Akinola, in which I appeared to Secretary of State. I'm not going to talk about that case because although the judgment was handed down recently, there are still potentially applications pending. And so it wouldn't be right for me to comment at this point in time. So I'm going to hand over to Alexa to deal with that case.
Thanks so much, Ben. As Ben has mentioned, the interpretation and effect of 3C is something the Court of Appeal has recently grappled with in the case of Akinola, and following judgment being handed down last month, deals with the issue of revival of 3C leave and hopefully providing guidance for future interpretation. Taking it back a step before we look at the facts of the case, up until recently, it was widely accepted that 3C leave, in fact, couldn't be revived at all. Where leave was extended under Section 3C, that extension had to be seamless. And once it came to an end, it was not something that could then be revived. This position, however, changed in 2019 with the case of Ramshini, where it was established that 3C leave in fact could be revived from the point when an appeal is instituted, the court then considering that to be when the first tier tribunal grants permission to appeal out of time. And following Ramshini, the Home Office in fact revised their Section 3C guidance to reflect this. However, the recent judgment of Akinola has moved the goalposts again, discounting the position set out by Upper Tribunal Judge Lane, resulting in the current Home Office guidance once more requiring revision. The specific facts of Akinola were in fact 3 conjoined appeals, Ms. Akinola, Mr. Abbas and Mr. Anwar. The appellants all entered the UK as students and had each applied to vary their existing leave to indefinite leave to remain. And this was on the ground of long residence. All 3 applications were refused. And Ms. Akinola had appealed out of time and was granted an extension of time to do so. Mr. Abbas had specifically appealed against a reconsideration decision, which had had the same effect as the original decision, which was a refusal of his application for indefinite leave to remain. And Mr. Allen appealed against the Upper Tribunal's decision to refuse to grant permission to judicially review their refusal. However, in each case, the question arose whether leave was extended by the operation of Section 3C, as it was relevant individually to whether they had built up the required 10 years of continuous lawful residence in the UK for indefinite leave to remain. And moving on to the legal issues in the case. The appeals concern the effect of Section 3C, firstly on appeals out of time, where extensions of time had been granted, and secondly, where there had been withdrawals or reconsiderations of refusal decisions. The section does not explain what happens when a decision is made to refuse a visa application and the applicant fails to then lodge an appeal in time, but the out of time appeal is then allowed. Section 2B of Section 3C, subsection, brings this 3C leave to an end, but subsection 2C sets out that a person has 3C leave whilst their appeal is pending. And once a late appeal is accepted, the appeal is then pending. And therefore, 2 main questions arose out of this. Does the person in fact have 3C leave? And if so, from when does this 3C leave start? And putting it another way, these 2 main questions can be phrased: once revived, is 3C leave rendered retroactively seamless, or does it in fact have future effect? Was it from the granting of the extension of time, or when the notice of appeal had been filed? There was a further question that arose in relation to the withdrawal and reconsiderations of decisions. And the question specifically in relation to this point was whether the withdrawal of a decision functionally equivalent to the quashing of a decision by the court, and that had the same or like result that an application for variation would not have been decided until a fresh decision was taken on the application, and therefore would leave continue to be extended under 3C2A in the meantime. The primary issue comprising it down for the court was whether 3C leave revived with future effect or retroactive effect, and therefore whether there was a gap in that leave. And the arguments advanced by each of the parties differed substantially. The Home Office advanced a position that 3C leave could revive from the date the tribunal allowed the appeal to be accepted late, and this would result in a gap in lawful status. And the appellants argued to the contrary, that the tribunal allowing the late appeal had retroactive effect and rendered 3C leave and subsequently their lawful immigration status as seamless with no gaps at all. Revival, the appellants argued, therefore ran from the day that the appeal was lodged. The decision handed down by the court was that the appeals were dismissed. And the court found that leave under Section 3C could be revived from the point at which an out-of-time appeal, where an extension of time is granted, is filed. And so it is the time at which the appeal is instituted, which is when the notice of appeal is filed. And particular attention is drawn to paragraph 56 of the judgment, where the court expressed their reluctance in being driven to the conclusion that the approach was the one taken by the Secretary of State, that leave was not retroactive, and that it was their reluctance in accepting that this conclusion was the correct one, even though it results in a gap in the protection afforded by 3C to applicants who appeal out of time, however good their reasons may be for the delay. And this conclusion produces, as they observed, an equivalence of approach between out-of-time appeals and withdrawals. It was interesting that the court did express, however, their hope that the Secretary of State would feel able to exercise her discretion to mitigate the disadvantages of the gap in relation to out-of-time appeals, in the same way as she has done in relation to withdrawn decisions. Moving on to paragraph 61 of the judgment, the court did then expand to say, to clarify their position in relation to the revival, that where an extension of time is granted, it seems that it will be granted up to the date when the notice of appeal was filed. And considering whether to grant such an extension, the tribunal will focus on the reasons for the delay up to that date. And it interestingly expressed some insight into reaching their decision that any further lapse of time between the date when the notice of appeal was filed and the date when the application for an extension of time is decided will depend upon the tribunal's own workload, resources and priorities, and will generally be irrelevant to the decision. And so in brief, the Court of Appeal have confirmed that 3C leave can be revived, and this starts when an appeal is made out of time with future effect, not retroactive effect, and runs from the date the notice of appeal was filed. The withdrawal of a decision did not have the consequence of causing leave to be extended retroactively under Section 3C from the date of the decision. It is revived for the future because from the date of withdrawal and until a fresh decision was taken, the application for variation could no longer be said to have been decided. As a consequence, taking it back to the specific appellants in this case, none of the appellants reached the 10-year continuous lawful residence mark to entitle them to indefinite leave to remain. Nonetheless, the decision is helpful to applicants who have filed out-of-time appeals, as they can protect themselves nonetheless from the hostile environment of being an overstayer, as it will become a pending appeal by Section 3C 2C, reviving their 3C leave from the date when the notice of appeal is filed. I believe it's at this juncture I will pass you over to Mark for the third section of the webinar.
I think it's also just before Mark takes over, I think it's worth saying, Alexa, that this is quite a big change. The Ramshini judgment was back in 2019. It took quite some time for the Home Office to change their guidance in December 2020. And so it's a big change that now 3C leave can be properly revived. And we're not quite sure how that's going to play out in the future as people start to get to the 10-year mark and try and apply for either 276B applications or outside the rules of 10 years. So it'd be quite interesting to see both how that revival works in practice when those calculations and how much discretion the Home Office are prepared to grant to applicants.
I think that's right, Bennett. I mean, it presents a whole new scenario which hadn't previously been considered. And in some of the examples I'm going to be looking at, then we'll see how actually that might raise some questions that the court's going to need to look at in future cases. So as I said, following on from Ben and Alexa, I will be hoping to tie it together with a bit more of a practical guide of how these cases and these sections tie together. And perhaps I can put it like this. They do work together, perhaps not as well as the Three Musketeers did, but I would perhaps approach it in this way. The first question I would ask at any given point would be, well, does my client's leave continue? And so I'd look at section 3C. The second question I would ask is, well, is there an exception to the overstay if I don't have leave? And I'd look at 39E. And then if I was making a long residence application, then I'd say, well, does my client have the 10 years continuous lawful residence? And I'd look at 276B. So we'll apply that sort of method, if we can, to an example that I'll take you through. So imagine a client comes to you in this situation. They've made an application, been granted leave, and towards the end of that limited leave, they've made a further application. That was made before the leave expired. And so when the first period of leave expires, they automatically get 3C leave until there is a decision. So we could ask the questions. 3C, does the leave continue? Yes, it does. It continues until there's a decision. Now, in this case, if there is a refusal, then it would continue until the end of an appeal period. And if there's an appeal in time, 3C says it will continue until the end of the appeal. But let's imagine your client has come to you and they have not appealed in time. So they have now entered a period of overstay. Well, you lodge an appeal out of time. Let's ask the questions again. 3C, does the leave continue? Well, no, it expired at the end of the appeal period. That's why you've got this period of overstay. So imagine now that you are granted your extension of time to appeal. Good news. And that means that we're in the Akinola situation and 3C leave is revived. Although you've appealed out of time, the 3C leave is revived, as if from the dead. But remember, we've heard from Alexa already, Akinola only has future effects. So that 3C leave doesn't go backwards to the end of your previous 3C leave. It has future effect from when you lodged the appeal out of time. So that period of overstay still remains. Let's say that your appeal is ultimately dismissed. Let's ask the questions. 3C, does the leave continue at that point? Well, no, it doesn't. It only goes up until the end of your appeal, until it's finally determined. So now you know you're entering a period of overstay. Let's ask the second question, 39E, is there an exception for this overstay? And the answer is, well, yes, if you apply within the 14-day window. I've got an example here, Ben referred to it earlier, of a Tier 1 investor case that we've been working on over the last year or so. It had a very similar situation. The client had limited leave as an investor. Towards the end of that limited leave, they applied, you can see it on the left-hand side of the screen, for indefinite leave to remain. And that decision didn't come before their leave expired, so they had 3C leave. Unfortunately, there was a refusal. We administratively reviewed it, requested that, and unfortunately, that refusal was upheld. So we looked at 3C and said, well, we don't have a continuation of 3C leave here, so we need to look at 39E. Actually, in our case, there was a Court of Appeal decision which came out after the original refusal had been upheld. And I'll cover it now because it will be of interest to those of you who deal with investor cases. It's the case of JW and others. And as you will probably be aware, the rules require that the funds that are invested are under the applicant's control. The upper tribunal in JW had decided that the funds were not under the appellant's control because there were restrictions on the use that it could be put to. In fact, it was a loan, and the loan agreement said it had to be invested in this particular fund. The upper tribunal said that's a restriction that means it is not really under the appellant's control. But the Court of Appeal overturned that and said, well, actually, that's not really the question. We can see at the top there, the natural meaning isn't about the destination of the money. It's about the relationship between the applicant and the money. And so it's about personal availability. And they said that the JW had unrestricted power to direct the proceeds of a loan are used for a qualifying investment. JW signed up to the loan agreement knowing that it would be invested and that that qualifying investment could be used for the purposes of their Tier 1 investor application. The Court of Appeal said that was sufficient control. So we had this decision. We were in a similar situation, and so we applied to judicially review the result of our administrative review on the basis of that new Court of Appeal decision. We asked the questions again. 3C, does the leave continue? No, because it doesn't apply to applications for judicial review. The second question, 39E, is there an exception for the overstay? Well, again, 39E doesn't apply to judicial review applications. That's why we made a fresh application, and we made it within the 39E window, that 14 days that we've referred to, which means that any period of overstay now is within the 39E exception, or you could say 39E applies to that overstay. That was a specific example that we had. Back to our more general example, let's say you have made your application within the 39E window. And so the period of overstay for your client is within the 39E exception. Rolling time forwards, unfortunately, there's a refusal, you appeal, unfortunately, that's dismissed. Let's ask the questions. Does leave continue? No. There's no existing leave to continue. You're already in a period of overstay. So 39E, is there an exception to the overstay? Well, let's look at 39E. 39E, it says, applies following a refusal of a previous application for leave, which was made in time. A previous application which was made in time. Well, the case of Ali, as referred to by Ben, said in time means before leave expires. Maybe seems obvious, but it's of significance in our example. The first application on the left in green was in time because it was made before leave expired. The second application in the middle in red was made within the 14-day window, but it was made after leave had expired. Even though it was within the 39E window, that's not enough. And so effectively, Ali is saying there's no second 39E window. You can't rely on it once and then rely on it again. You can't stack up your applications relying on 39E. And so for our clients, once the second appeal is dismissed, that's a period of overstay which is not within the 39E exception. We've just rolled back a little bit here. Let's imagine instead that your second application is granted. And so there's a period of leave at last. We're looking at the overall now, and there are two periods of overstay. The first in red, the second an overstay within the 39E exception. But what do those two periods of overstay mean for any application that your client might make for long residence? 276B, as we know, says you need to show 10 years continuous lawful residence. So let's imagine that your client gets to 10 years at the blue dotted line on the right-hand side. Well, the key case here is the case of Hock, as Ben's referred to. And as he also said, the case law is not clear and it's not settled. The case of Hock overturned a previous decision, the case of Masum Ahmed, but it was, in that case, I should say, was in 2019. So we're really having quite a quick turnaround in terms of where the law is going in this area. But even in the case of Hock, it was 3 Lord Justices, one of them dissented, so it wasn't a unanimous decision. And the court did have some very severe criticism for the Home Office in terms of the way that the appeals were drafted. I beg your pardon, the way that the rules are drafted. And so it's certainly an area which is still in flux. But perhaps we can go this far. We can say, in summary, Hock says that short, bookended periods of overstay will be disregarded when you're looking at adding up your 10 years for a long residence application. Let's break that down a little bit. Bookended means that there's leave before and leave after. Incidentally, you may already know, in Hock, all of the appellants actually only had open-ended periods of leave, where they had periods of overstay, where there was a period of leave before, but no period of leave afterwards. So that's another reason why a future court might choose to review the approach taken in Hock. Back to our case, the first period of overstay on the left-hand side in red, well, that is bookended. It's got 3C leave on the left before it and 3C leave on the right after it. It may also be a short period if the appeal was only a short amount out of time. And so you could argue that Hock applies and that should be disregarded. But this is the Akinola situation where there's an appeal out of time. It's not clear that period of overstay will necessarily be disregarded. It wasn't a situation that existed for any of the appellants in Hock. And although it's arguable, it's not an overstay within the 39E exception, because 39E applies to fresh applications, and this was an appeal. So I think if it's short, it may be that could be disregarded. Let's look at the second period of appeal. Is it bookended? Yes, it appears to be bookended. It's got 3C leave on one side, and it's got leave after it from the fresh application that was made. It's also within the 39E exception. That's a positive. The application was made timeously after your previous appeal was dismissed. But potentially it's a very long period whilst the Home Office were considering the decision. And so although it's arguable because the application was made within the 39E window, there's no clarity really about whether that would be disregarded when you're counting up the 10-year period. As Ben referred to earlier, there's a case of ASIF that dealt with this. They actually said that yes, a long period could be disregarded, but that case only went to the upper tribunal and it hasn't been appealed. And so we don't have anything on a sort of Court of Appeal level that does deal with that question yet. So as much as I'd like to give you a very clear answer to what this means for any of your long residence applications, what we can see is that the different sections don't quite work as well together as we would like them to. And we really need to keep our eye on the Court of Appeal for future decisions that might clear up some of these areas of issue. Maybe the takeaway then is these 3 sections and the questions: does leave continue? 3C. Is there an exception for the overstay? 39E, and then of course, do you have the 10 years continuous lawful residence? And we need to consider all of those and how they work together when we're advising our clients on the best way forward. Now, I hope that has been informative for you. Hope that's been helpful and at least a little bit practical at the same time. We're now going to have some time for some questions. If you had any questions or you've got any that you want to send to us, you can click the Q&A button at the bottom of your screen, and we'll do our best to answer them. So I will hand back to Ben so that he can just field some of those questions.
Thanks very much, Mark, and thanks for setting out what is an extremely tortuous area in such clarity with the timeline. What I wanted to deal with was we've had a couple of questions through on my mobile. Thanks to Tess for sending them through. If there are any other questions, and just waiting for some other questions to come through, so I'll try and field them as they come through. But the first question we've had was for the 10-year long residence route, is there any point making an application if you already missed the 39E 14-day window? I mean, I think the answer to that is yes, there is, because there's another grey area which we haven't really touched on. It's referred to in passing in both Hock and Akinola, and there's another case coming up in the autumn, potentially in the Court of Appeal, is the discretion the Home Office can exercise in the long residence guidance. So we've talked a lot about 276 B and how that works, but that's within the rules. And there are scenarios where the guidance says, the Home Office guidance says, well, you can ignore those periods in certain circumstances, but it's far from clear what those circumstances are. So depending on the personal circumstances of your client, you get to 10 years and you've got some gaps, you may be able to persuade the Home Office to look at outside the rules to help. Now, there's another question come in. So when further letters of representation submitted within 39E 14, the 39E 14 days and granted under good character for naturalisation after 10 years, and ILR, sorry, just read the...
While Ben's just having a look at that, I did just want to come back on what Ben had said before, because it may very well be that the issue of Home Office discretion, it comes a bit more centre stage in these cases. And I know that it was something that was certainly referred to in argument in Hock and other cases about the way that the Home Office has have disregarded short periods of overstay in the past when applying the sort of 10-year route. And so it may be, even if we don't have clarity on on what the rules say an application within the rules should be, it may be that we can certainly use the decisions as leverage for arguing that there should be discretion exercised.
There's got quite a long question about 39E and 14 days. I can't read it all out now, and I'm happy to have a discussion afterwards with the question answer. But I mean, the answer, the question is essentially, if a person's leave to remain was made on or after 24th of November 2016, and the application did not fall for refusal on the grounds of overstaying because an exception to paragraph 39E of the immigration rules applied, is this still the case further to Akinola? I think, just quite a long question. Yes, Akinola hasn't really changed in relation to 39E or 276 as such. It just dealt with the interaction between the two. What Akinola did was move the goalposts of whether 3C leave was change how 3C leave is interpreted. So 3C leave can revive as per the Home Office guidance per Ramshini in 2019, and the Home Office guidance changed in December. But at that point, the Home Office said, and the court said, it revived from the point that the tribunal said you're allowed an out-of-time appeal, which left appellants at the vagaries of the tribunal's administrative burden. And then that changed in order to, what's changed in Akinola was that it now is from the, which is slightly fairer, I think, it's from the point at which the out-of-time appeal is put in, which could just be 1 day out of time, or it could be months out of time.
There's another question I know that's coming, but I did want to respond to what you said, because I think probably the short answer on the Akinola versus the 39E question is that Akinola is really about out-of-time appeals. What happens when there's an out-of-time appeal? But 39E is really about new applications being made, and so that's why Akinola really is probably aiming at a different target. So you might find that both of them, both 39E applications and that Akinola out-of-time appeal situation occur for the same client, like we went through in our example, but they probably won't like coincide at the same point.
There's there's one more question here. So one of the questions came in is, how long do you think it's too long for an overstay to count towards 10 years lawful residence? Mark, what do you think the answer to that is?
Well, I mean, it's fair to say, isn't it, Ben, that we were discussing this earlier today and racking our brains for it, and there's no one easy answer, unfortunately. I mean, I think Ben said that for the Home Office, they've been arguing in cases that actually, you need to be looking at something like the 39E window of 14 days, but we've already seen in the case of Asif, I think that was 507 yeah. days, because he made the application, but the Home Office took a long time to decide, and so there was actually a really long period of overstay, as not uncommon, whilst the decision was being made. So I mean, how long? The shorter the better, but if the court continues to interpret Hock quite so generously, then it could be that, if you've made the application soon after the last one's been dismissed, then all of the period of overstay could be disregarded. I mean, that's the sort of best case scenario for the applicant that we could see. Would you agree with that, Ben?
Yeah. There's hang on, suddenly new. There's a couple more questions come through. There's one more. I'm going to paraphrase the questions, because they're quite long. Really, whether 3C leave pertains in an out-of-time appeal. When does 3C leave start? I think this is in relation to EU settled status applications. And I can't. It's too long to answer over the internet now. But yeah. So this is the question really is. If somebody has made an out-of-time appeal, does their 3C leave revive? So yes and no. They're out of time. If you've made an out-of-time appeal, your 3C leave will backdate at the point where the tribunal accepts a legitimate reason for your appeal being out of time. So you're left. So some people are left in a hiatus. So if you have put an out-of-time appeal in, but the tribunal haven't made a decision on whether you're going to be allowed to forward that appeal, at that point you don't have 3C leave. So which is the intellectual problem that Alexa described earlier, of the retroactive status that you're granted, but you're only granted that retroactive status upon a tribunal saying, I accept that this is a legitimate reason that this is out of time. So it's not a perfect scenario by any means. I hope that answers the question. Again, if you've got slightly more detailed questions, please send us an email afterwards, and we'll try and deal with it. So I have to lean forward because the print's too small for me to see.
Oh, maybe I can just interject. I don't know whether Alexa has any thoughts on that last one, but I think it's a slight oddity about Akinola that they couch the whole discussion in terms of when you have an out of time appeal, when does your 3C leave start? And it's couched in terms of, is it retroactive? Does it start from before the decision to allow your out of time appeal, or does it only have effects in the future? And actually, in the end, they kind of went for something in the middle, didn't they? Because they said, oh, it doesn't have effect retroactively all the way back to when your old period of 3C leave ended, but it does go back to the time that you lodged the form. But of course, you won't know that until your extension of time has been granted or refused. I don't know whether that was something Alexa wanted to say to comment on, but that was how I understood it.
No, absolutely, Mark. And it's strange in that they make a clear distinction in their judgment that it has future effect, not retroactive effect, but naturally, by allowing your out of time appeal and it reviving from the date when the notice of appeal is filed, you will find out that that date is retroactive because it has now passed. But it does still mean that there is a gap in that 3C leave.
Yeah, so there is that hiatus, and as Ben said, and you can't just lodge your out of time appeal and assume everything's fine. You have to wait and find out if you've got the extension of time. Yeah.
So we've got another exam status question that has come in, which I think is going to be the last one. Again, I'm not going to be able to answer it in full necessarily, because it's quite long to read out. It's to do with what control means under paragraph 39E, and a number of particular cases. 2 points really come from it. Is it worth making a protective application for within the 39E window? And do you think you could use the JW and others to argue about control or not? I think Mark and I have gone to. I think you should make a protective application. I think that's better. It's at least safer. The JW, what control means, and whether you could use the JW case within the meaning of 39E, I think is not going to work. And but I may have slightly misunderstood the question. So again, if you want to email me or Tessa or Mark or Alexa afterwards, I can spend a bit more time on it. But the JW case really was to do with investment control. So the JW case was to do with an investment firm which loaned money to the investors. They loaned the money on a particular basis that they were going to invest in the particular company. The Home Office didn't like that because the particular company in that case, the investment firm and the owner of the investment firm and the owner of the company were husband and wife. That wasn't properly declared, they said, and therefore that was essentially a ruse to get around the immigration controls. But the Court of Appeal said, well, it's actually a legitimate investment. It may not be a very good investment, but and we don't particularly like it, but it falls within the rules. And so I hope that answers your question in relation to control. I think the JW case really is to do very much with investment control. I mean, there's a whole set of cases involving dolphin investments and other investment vehicles which have been used and are now problematically in problems with the FCA. And a lot of people who've obtained their immigration status through those firms are in all sorts of trouble in terms of making a legitimate investment and then having their investment pulled from under them. I'd be happy to discuss that a bit more length afterwards, but I'm not sure I can answer every single point that's in what was a very detailed question. Well, I think that's. Thank you all for coming. I think we've and thank you for all the questions. I hope I've answered them. We've asked them as best we can. Again, if you've got any more questions or you'd like to discuss anything further with us, then you've got Tessa's email and she'll forward it on to us. But thank you very much to Mark and to Alexa and for Tessa organising it and for all of you coming. Thank you very much, and hope to see you in the future.